Please, Lordship.
Yes.
For listing of IL, Lordship, in a criminal jail appeal. For early hearing, Lordship. In 10th of February, Lordship.
You first filed the application for early hearing.
I have already filed, Lordship.
So where is it?
Lordship,
So let it come before this court. We'll decide on that application.
let it come on 10th of February, Lordship.
Let what come? Let the IA come.
Listing of IL, Lordship.
Huh?
Listing of the IL, Lordship.
Okay, then let it come end of February. Let the IA. Give a date. But it is the IA. Huh?
May I please, Your Lordship? I would like to mention item number 13 of daily list. Kindly
Yes.
pass over the matter for 3 weeks.
Why?
We haven't received any instructions from the clients. So,
No instructions from the client. Who is your counsel? Mr. S.C. Biswas.
yes, Vishwas.
Right. Adjournment prayer has been made on behalf of Mr. S.C. Biswas, who submits that no instructions have been received from the appellants. You mean no material instructions, or what type of instruction? Oral instructions or material instructions? Which one?
My senior just told me to instruct me to say this.
Okay.
So, I'm not aware of it.
And no paper book has been made. I think. No paper book. The records haven't come. Let us see why the records haven't come. Has the records been called for? Is the IA give the main case? Huh? Madam, you have not even taken steps upon the respondent number 2 in terms of the order passed by this court.
We'll take fresh steps.
What fresh steps? You have not even taken the first step.
First step.
Where is the question of fresh steps?
We'll take the first step, my lord.
When?
Today, tomorrow, within 2 days.
Within 2 days.
Right. It is noticed that in the order dated 16/11/22, the appellant was to take steps for service of notice upon the respondent number 2. However, in terms of the office note dated 8/12/22, no steps have been taken by the appellant for service of notice upon the respondent. Miss
Devnath.
Miss S. Devnath, appearing for Mr. S.C. Biswas, our learned counsel for the appellant, submits steps for service of notice upon the respondent number 2 shall be taken within 2 days. I'll list the matter after 4 weeks. In the meantime, the registry is to call for the LCR.
Obliged.
I am the legal aid counselor.
Perhaps this has come up for the first time.
Okay,
The appellant has been convicted under section 4 of the POCSO Act Club,
section 4,
section 4, and imprisonment of 20 years.
aggravated.
So the notice to the informant should be.
Why?
Supreme Court has recently said
There
there is a decision today. We don't judge it.
When was the Judge Singh's judgment passed?
That was the judgment of this year, where it
This
is
year?
said.
This year?
Of this year by the Honorable Supreme Court.
This year?
This
after
year.
your lordship
22,
passed that
22.
order.
Okay,
2022.
Yes.
22, not-
22, not 23.
That's why.
I mean, there, Honorable Supreme Court said that in cases of POXO, the victim needs to be heard in every stages,
Let
from
us see.
bail to conviction.
Yesterday I read out that, your lordship.
No, you see, the question is whether participatory rights are there or not. Participatory rights they have got.
Yes, under the CRPC, it's not there.
You see, participatory rights they have got. So I
Mm.
want to see the judgment because I think this issue we have taken it up earlier.
Mm. But then,
No, the committee, the High Court.
yes,
committee
yes.
for the-
And the High Court rules were also amended and all, but
Correct.
after that, the judgment is passed.
But subsequently, I think last year, sometime in October, November, we have again considered
Hmm.
whether it is required to issue notice.
Mm.
You see, otherwise what happens is notice is issued and they don't receive, and then the appeal gets stuck,
Yes, it gets delayed.
get
Yes.
delayed. So I think we have already taken a decision that it's not required, and they have got all participatory rights.
But in all other cases, it will not be required. But in view of the Honorable Supreme Court judgment.
Let us see the Supreme Court
Yes,
order.
Jagjit Singh, no, yes.
Yesterday read out some portions, my lord.
No, madam, I need the
2022
citation.
9 SCC.
2000,
22-9 SCC 321.
2022 9 SCC
321.
321. Please give me the judgment.
Para 15 onwards. Google search for the copy. Google search.
No, not in all cases, but in all cases, there is differentiation. No, that is not mentioned. Yes, so 9 SSA, 22-9 from the bodies. So far I could remember. In Margaret. Plan network.
Okay, right. Heard, Mr.
Jay Das.
Huh?
Jay Das.
J. Das, Learned Counsel for the Learned Legal Aid Counsel.
Legal.
Legal aid counsel.
Learned Legal Aid Counsel for the appellant who submits that the appellant has been convicted under Section 4 of the POCSO Act 2012 and convicted to undergo 20 years
20 years.
RI
RI
with a fine of rupees
10,000.
10,000, in default.
In the default of payment.
Another period of 6 months.
Another.
That's right. Or RI.
All right.
Another period of 6 months. RI. Admit the
Questions
appeal.
which I have?
Wide judgment and order dated.
Judgment dated 29/10/2022 and order dated
Page. Judgment and order dated. Where is the page?
page lordship 9. 9 of the memo of appeal.
Page
Page 9
9.
of the memo of appeal.
Why judgment and order dated 29/10/22 passed by the special judge POCSO Golaghat in special POCSO case number 38/2021.
Yes.
Any sentence order?
Sentence order lordship 31/10/2022.
And sentence order dated 31/10/22. Admit the appeal, call for the LCR. Issue notice to the respondent. Ms. S.
Jahan,
Jahan,
yes, 8.
Jahan S.
S. Jahan.
Ms. S. Jahan, additional PP or PP,
That's additional.
still additional,
Still additional.
additional PP, accept notice on behalf of the respondent number 1. appellant to take steps for service of notice upon the respondent number 2. Oh no, registry to take.
Registry.
You pay from my own pocket.
Legally it counts.
Registry to take steps for service of notice upon the respondent number 2 by a registered post with any within. Don't say within. List the matter after receipt of the LCA.
I'll bring the printout tomorrow.
There is
Lordship.
a IA also that may be considered after this.
They're in the IA, right?
Oh, I
Heard Miss J. Das, Learned Counsel for the
copy this one,
applicant.
Mahalakshmi.
Miss S. Jahan. Is it
389, not
After
389.
receipt of
389?
I'll file my objection also in the
Mrs.
meantime.
Jahan, additional PP is granted.
2 weeks.
2 weeks time to file written objection. List the matter after 4 weeks.
Lordship.
Okay.
Same
sir.
lordship, he was convicted under section 4 of the POCSO Act and 376(3).
Okay, heard Miss
R. Chaudhary.
R. Chaudhary, Learned Counsel for. Same thing, huh? Same order. Except now it will be date of judgment is 5/12/22. Convicted under section 4, huh? By judgment dated 5/12/22, passed by the special court.
20 years
Which is
fine
Tirang,
of rupees,
Tirang.
lordship.
In special POCSO case number 4 of 2022, judgment and order dated 5/12/22 and date of sentence 3/1/23. And what is the same 20 years?
Lordship 20 years, fine of rupees 40,000 in default
40,000.
3 months.
But
And-
it is under 376(3).
376(3), lordship.
376 or POCSO?
Both were
Lordship,
there.
both are
So,
there, but he
so
was
which is the most severe sentence?
Huh. So 376(3) comes out as a serious, more serious.
So then it's
Waiver of
376(3).
376.
So it is not POCSO, it is 376(3).
Conviction under
IPC.
was both. Conviction was under both.
But sentence under.
Sentence under
Okay,
376.
conviction under 376(3) IPC and section 4 of the POCSO Act.
Yes.
And sentence under 4 of the
376.
376(3)
of it.
IPC.
I'll file my objection 2 weeks.
Then in the
Lordship, can it be after 3 weeks, lordship?
after 3 weeks in the IA, you put their names and just say that you'll give it 3 weeks time to file
Lordship.
written objection.
Obliged.
Please, Lordship. So in this case, I am appearing as an amicus curiae for the appellant Lordship. Office note 27/1/2022 shows that service report is awaited upon respondent number 2 Lordship. But that is not required Lordship in view of the notification Lordship.
What is this matter?
This is
302.
302.
Live in
302 not required. Not.
Not
So then what to do?
make a fix for hearing Lordship,
Hearing.
final hearing.
Hear it. Okay, right. The learned amicus curiae is present along with Miss S. Jahan, additional PP. Notice has been issued to the respondent number 2 on 17/8/2021. And in terms of section 26.
Of the general clauses. No, general clauses will actually not come in these criminal appeals.
Okay.
Because in general
Okay,
clauses act,
just say, notice has been issued to the respondent number 2
let it be
on-
kept pending or awaited or anything.
on 17/8/2021. According to the notice deemed to be served.
Actually, deeming thing will not come in criminal
not
appeal.
appeal.
Lordship, in view of the notification, it is no longer obligatory Lordship. Wait.
In view of the, which is the notification?
Lordship,
Came on 21.
2021 notification.
21/12.
2021.
Out here, it is, I don't think it's incorporated in this book as on this.
I think in the new High Court rules.
This is.
The rule is
2000
amended
recent-
Lordship.
हाँ,
21/12/2021.
no, High Court rules का कमाल है ना.
Which is the rule? Where is it? Which chapter?
Chapter 5A होता ना ये जो appeal होते.
Regarding that appeal and revision Lordship, 5 may be Lordship.
Chapter?
ये लिखा हुआ है. Notification पास है.
Notification 9.
Notification का बोर्ड website ত ওলাব।
ৱেবছাইটত আছে। 21/12/2021 হাইকোর্ট ৱেবছাইট 21/12/2021 regarding এইটো এই implement of respondent এপিলত নালাগে না 374
Yes, this is in which one? Order by service.
একো নাই
In separate, in supersession of all previous Iman by 374 deleting. Rule 1A. Rule 1A of chapter key. In supersession of all the previous orders, the Guwahati High Court has been pleased to amend chapter 11. Chapter 11 of rules of Guwahati High Court.
Chapter 11,
Chapter 11, rule 1, capital A.
chapter 11 is with me.
304 374 to omit
374, deleting 374.
বাকি কিটা আছে
Yeah.
Deleting
374
374.
is deleted lot.
In view of rule chapter, in view of chapter 11, Roman 11, rule 1, capital A of the Guwahati High Court rule, comma. Notice need not be served upon the, that's point number 2. So accordingly,
Gotcha.
as the parties have been given their paper book, lists the matter for hearing in usual court.
Yes.
What about the suspension of sentence? Is there nothing?
No,
Nothing,
there is
nothing.
nothing. It's a
jail
jail
appeal
appeal.
jail appeal
Then
so in this case also I am appearing as amicus curiae lordship
state
same lordship but notice was not issued to respondent number 2
notice are issued.
notice was not issued lordship
Notice is
in
not
view of the
issued.
notification lordship
Mr.
and Hassan lord
No, the learned amicus curiae and Miss S. Jahan, learned additional PP, submit that they have received the paper book
22,
voluntary লাগিব পাৰে।
noted matter, no.
in view of chapter 11, section 1A of the Guwahati High Court rule, comma. Notice is not required to be issued to the informant. Accordingly, list this matter for hearing in usual court.
lordship obliged lordship
So paper book, who is for the?
Yes, paper book is there. Nabo Kumar Kolita, he otherwise appears. He
Okay,
is a daily, he comes
So-
daily.
so okay, right. So paper book have been furnished to him or not?
Yes, yes, perhaps with it.
Huh? We say it's been
We'll
furnished.
have to, because we also have got to, he has
Okay,
to
right.
get.
Miss L. Jahan, additional PP submit that she has received copy of the paper book. Accordingly, list this matter for hearing in usual court.
This is POXO, otherwise Lordship can see whether
Oh.
service is completed. No, no, Karun, no,
Aye. You have got to tell me all those things. Unserved notice for point number 2 has been received with postal remark, no such addressee.
Oh,
Lordship, then the legal aid counsel. be
legal aid
appointed
counsel.
From the panel,
Already appointed.
Oh, acha.
then her name, his or her name is not shown in the court.
For the victim,
Victim.
legal aid
Acha, for the
counsel.
victim.
Yes.
For the victim.
Acha.
Others will get delayed, my lord.
It will get delayed.
Yes. For the victim.
Okay, right.
Either Lordship can issue notice through the police and find out where
They
she
said
is.
that no such addressee.
I can
No
delay
such
the
address. Gotcha.
There is no such addressee, then what to do? Right.
She might have changed her address and all, that can happen.
Okay, right. Miss L. Jahan, Miss L. Jahan, learned additional PP submits that she has received the paper book. Office note dated 7/2/23 states that unserved notice correspondent number 2 bracket informant has been received with postal remark inverted commas no such addressee comma
Okay.
returned to sender ed to sender inverted commas to. In view of the above comma who should we appoint?
There's a list.
No, you are
In fact, here, Here the father, the accused is the father of the victim.
Stepchild or something?
No, Lordship, husband, the wife, the mother is the informant. My husband took advantage of it and committed rape on my daughter.
My God. On his daughter.
Yes, his own daughter. Mother is the informant. Yeah, David Banikya.
Miss Meghali Burman
Is available. Yes.
is appointed as amicus curiae
Lordship.
to represent the
informant.
respondent number
For, yes, respond number 2.
two. Registry to provide paper book to the to Miss Meghali Burman. List the matter for hearing in usual court.
Lordship. No, okay. 6 Deepak Bora. Deepak
This is
Bora.
what, POXO again or what?
Lordship, I'll just read. This is no 302.
Is it? Okay. Why this amicus not coming?
Deepak Bora, otherwise we know is a Boga ke law. Oh. Honey? One Deepak Bora, we know he's appointed as a member of the Foreigners Tribunal. Whether he is the one. No, honey.
This is 13/6/22. Heard Mr. Deepak Bora, learned amicus curiae.
Oh.
Is it the one who's been gone or when was that person appointed?
There's another one, Deepak Bora. Lordship can await then. On the next day, if he doesn't come, then Lordship can appoint someone else. But
Okay, right. So, Miss S. Jahan, no one appears for the learned amicus curiae is absent. Miss S. Jahan, learned APP, appears for the state and submits that she has received a copy of the paper. List the matter for hearing in usual court. Yes, what is your case?
My lord, as per office note dated 27/1/23, your lordship, service report on respondent number 2 is waited. This is POXO. Right.
Okay, right. So has the LCR arrived? LCR arrived. So paper book is necessary or not?
Yes, my lord.
Right. The appellant's counsel is present along with Miss B. Boyan. Additional PP?
Yes, my lord.
Additional PP. The LCR has also arrived. Registry to prepare the paper book. To stop.
Can one be appointed?
Yes, we are going to appoint.
Lordship, Mr. Ujjwal Chaudhary is there, legal aid counsel. He may be appointed.
Okay. Office note dated
27.
27/1/23 states that no service report nor AD card received from the respondent number 2. Though notice has been issued on 10/1/23. 10/1/20? No, 10/1/23.
9. I have sent it 9/1/23, your lord.
Huh?
Recently has taken steps. Then your lordship.
We'll have to wait. 10/1/23, then we'll have to wait. I think it's 10/1/23. No?
Yes,
Then we have to wait.
yes.
Await service report on the respondent number 2. List the matter after.
One more prayer, my lord. My name is not reflecting in the call list, your lord.
What is your name?
A. Rahman.
Huh?
A. Rahman.
Your Vakalat number is there?
Yes, your lord.
Registry to reflect the name of Mr. A. Raman
Right.
as counsel for the appellant in the cause list.
Master.
Yes.
No, this IA has been listed for my lord consideration of bail. This appellant has been convicted, my lord, under section 376 AB of the Indian Penal Code. Read with section 6 of the my lord
76.
AB.
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 AB. Read with?
Rape a
Section
minor
6.
under 12 years of age.
Oh,
And read with my lord section 6 of the my lord
POCSO Act.
POCSO Act. And sentenced to life imprisonment.
so you want the sentence to be suspended?
My lord. Here only problem is that, my lord, the place of occurrence is a very, my lord, the thickly populated next door, next room, there were, my lord, members were there, some other members. And my lord, the defense witness, my lord, the appellant's father, mother, they were also present there, my lord, but their statement were not recorded. So they were, my lord, examined as the defense witnesses, my lord.
Who are examined defense witnesses? Mother and father
Mother, father
of
they-
the
of the
accused.
appellant.
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 Okay.
They were all present there on the, my lord, Mag Bihu, 16th of, my lord, January.
Mark Bihu,
Mag Bihu.
eating and drinking.
My lord. But all were there, but they were, my lord, examined as the defense witnesses. Their, my lord, evidence were not considered. And my lord, whether, my lord, actual rape was there or not, my lord, whether it will be a case of
It's not
370.
required. Actual rape is not required. Even if you touch,
But,
touch is required.
but
You
my
don't
lord,
have to. You don't have to penetrate. Penetration also. If there's 1 millimeter penetration or touch is enough.
that is there, my lord. Only because penetrative sexual assault, my lord, that is section 6.
Penetration does not give the length of penetration. It talks about just a millimeter also. That
That
also
is,
included.
that is there, my lord. And there was delay of lodging the, my lord, FIR. 16th was the, my lord, occurrence. 19th, my lord, 16th itself, it was known to them. And FIR was lodged on, my lord, 19th. And on the same building, my lord.
Same
It is
building.
Same building on the rooftop. And adjacent room, my lord, this, their relative of the, my lord, informant were also, my lord, they were residing.
That's all.
That's all, my lord. I leave it to your lordship, my lord, because victims, my lord, evidence is there. So it's a, for POSCO, my lord, it's a difficult to get bail, my lord. I
Any
understand.
doctors?
Doctor examined, doctor didn't find it, my lord, recent any sexual that thing, my lord.
No injury mark.
No injury mark was found.
But evidence of
But
the
evidence of the victim,
executrix
my
is
lord,
there.
POSCO, it is, that is against me, my lord.
Okay, right. Yes, madam. Anything to?
In fact, the incident took place at the rooftop,
Okay.
and he has a room there. So when she went to collect the drying clothes
Clothes.
being dried there, and
He
then
was dragged
he,
inside his room.
he dragged inside, and she was sexually abused. There may not be anything more than that, but sexually abused. Then she somehow got away from the clutches.
So what is the punishment?
Life imprisonment
Life-
I have been given.
Section 6.
376 AB is there.
But the sentencing is under section
Vote.
both. Nahi?
Vote.
How can it be both?
Appellant was
Read with
convicted
section 6 of
and
the.
was sentenced to undergo, no, only 6. Only 6. 376 is not there, AB.
So I think that
That is properly done.
when was it done? When was the judgment order passed?
Judgment is passed on, my lord, 11/7/2022. 11/7. Last one, Kursil, na?
And
Last one.
delay, they went and met the parents of the appellant. And then they complained to them, they wanted to have some solution. So that resulted in some delay in lodging the
4 days
FIR.
delay, my lord. Same house. They were almost residing in the same house.
Should have paid some money, maybe.
My lord, that could have been better.
Maybe. On hindsight.
My lord. Here also, my lord, 1 lakh fine has been paid. 1 lakh
And-
sentence, my lord, fine of 1 lakh is also there.
And the doctor's examination was after 3 days of the incident. So nothing was found. She was abused only. So the paper book is ready. Let it come for hearing, final hearing. But then 22 matter, it will take some time.
Anyway, we can always, okay, we are dismissing this.
My lord.
Her statement is consistent, both before magistrate and the court.
Heard, Mr.
BM Chaudhary, my lord.
B.M. Chaudhary, learned counsel for the
Appellant.
appellant. Who
Only
submits
person, no? Yeah,
Informant
that
is there.
the,
I'm the informant, my lord.
Mr. For the
my
appellant.
lord.
Ms. S. Jahan, additional PP appears for the state, while Mr. A. Bhattacharjee
Yes.
appears for the informant.
Yes.
This point number 2. Application has been made for suspending the operation of the interim judgment order dated 7/7/2022 and order of sentence dated 11/7/22, by which the petitioner has been, by which the appellant has been convicted under section 376 AB, IPC, read with section 6 of the POCSO Act 2000.
My lord, there is a mistake, my lord, in our, my lord, post title. We have mistakenly written 376 AD. It is, my lord, convicted under section 6 of the, my
That
lord.
doesn't matter, full stop.
Sentence. Conviction.
Convicted under?
Under both.
Under both. full
Under
stop.
both, but sentencing
Sentence
only.
Under
the-
Moscow.
The petitioner was thereafter, the appellant was thereafter sentenced to undergo RI for life with a fine of rupees 1 lakh, in default, RI for 1 year.
6 of,
Under section 6 of the POCSO Act. Vice sentence order dated
11/7.
11/6. Don't say that. Why look at that? We've already said in the beginning. Huh? What's that? The appellant's counsel submit that the doctor's evidence did not record any bruises or injury. In the prosecuting, and neither was there any evidence of rape having been committed. He also submits that the FIR was lodged 3 days after the alleged incident, that is on 19/1/2020, while the incident apparently occurred on 16/1/2020. That's all.
that's all, my lord.
Next para. Ms. S. Jahan, no, the learned counsel, the learned additional PP, and Mr. S. Bhattacharjee, learned counsel for the informant, submit that as the prosecutrix has given her statement under section 164 CRPC, which is exactly similar to her evidence given during the trial. There is no infirmity with the sentence imposed upon the petition. On considering the fact that the prosecutor's evidence at prosecuting evidence was against the appellant, and keeping in view the provisions of the section with which under which the appellant has been convicted, we do not find any ground to suspend the sentence imposed upon the petitioner. While sentence order dated
11/7.
11/7/2022 passed by the Special
Additional-
Judge Pokso Dubri in special case number 27/22. The application for suspending the said sentence is accordingly rejected. And in the main case, you write,
Paper book is ready, my lord.
the counsels for the appellant and counsels for the respondent submit that paper book has been furnished to all of them accordingly. List this matter.
I have not received the paper.
Oh,
Normally,
Okay.
we both
Okay,
receive. but-
that's right. Mr. B.M. Chaudhary, learned counsel for the appellant, and Ms. S. Jahan, learned additional PP. Submit that paper book has been furnished to them. However, Mr. S. Bhattacharjee submitted. K. Bhattacharjee, counsel for that is point number 2, submits that he has not been furnished a copy of the paper book till date. Registry to furnish a copy of the paper book to Mr. K. Bhattacharjee. This is the matter for hearing of individual. Or when?
Whenever you want.
When do you want?
But after the Rongali Viva, after April, my lord.
May,
Me,
in the month of May.
In the month of May.
Lordship.
I am obliged, Lordship.
Actually, life imprisonment.
Life imprisonment.
Anything from 10 to life, I think that is what is provided for.
But
But-
life is quite hard. Apparently.
This should little harsh, that also I concede. During hearing, Lordship can reduce it down.
Just a thought.
My
Mm.
lord. I am obliged,
But
Lordship.
she is below 12 years now.
Yeah, below
10
10
years.
This is
That
10
is there,
years,
my lord.
too young.
How many people can you put inside jail?
Mm.
I do not know the state of affairs here in this state. But in at least in Aizawl, in Mizoram, I know, in Aizawl. The central jail in Aizawl is holding double the capacity. Oh,
Here
double the
also it's
capacity.
crowded, but we have so
Now,
many jails.
Lordship, people are arrested in bulk in the name of child marriages. So it
And
will be
all
too crowded,
transferred
my
to-
lord.
No,
Yes,
it
sir,
all,
my lord.
they are all transferred to Gwalpara, my lord. The detention camp,
Okay.
Oh, yes.
that accommodated
Detention camp of
about
Nisarg.
3,000 people. 3-story building.
No, but then that way, though, the ratio of the population and the vis-a-vis the persons who are put in jail, it's quite reasonable because you have got what's the population of Assam and how many crores?
2 no?
Four-
2 crores.
Nearly 2
Yeah,
crores.
nearly
2 crores.
Huh?
Nearly 2 crores.
Around 2 crores. Mizoram is how much? Around 12, 11 lakhs.
Yes, and we have so many jails here. But it's crowded.
Okay, next.
Obliged, Lordship.
Yes, what is this?
Objection file is it? No, first time.
Application 129 days. Any objection?
Lordship?
129 days in filing the appeal.
Oh, Lordship,
No,
nothing,
no.
it may be-
Okay, it is. Right.
I am for respondent number
Huh?
2, my lord. I am for respondent number 2, my lord.
Not mentioned. That doesn't
no
matter.
objection আছে নেকি?
Power is it?
কন্দন কৰে। কন্দন।
Okay. Right. Huh?
129 days.
So, right. Heard, Mr.
MS Alam.
Learned counsel for the applicant. Also heard Miss S. Jahan, learned additional PP. And Miss,
And there,
oh, sorry, Miss B. Buyan, learned additional PP.
Mr.
And
Ahmed.
H.R. Ahmed, learned counsel for the response number 2. This is an application under Section 5 of the Limitation Act 1963 for condoning the delay of 129 days in filing the appeal against the judgment and order dated 4/3/22 passed by the Special Judge Pokraja in case number Special 08 of 2017, by which the applicant has been convicted under
Section
6 of POCSO.
Section 6 of the POCSO Act and sentenced to undergo
20 years,
RI 20 years with a fine of
50,000 lord.
15,000.
50. He said
50.
50.
50. In default,
In default, 1 year lord.
RI or SI?
SI or
In default, only in default. Default 1 year.
For 1
Earlier,
SI.
Default imprisonment for 1 year.
1 year.
Full stop. Next, the counsels for the respondents submit that they do not have any objection to the delay being put up. On considering the reasons given for the delay in the application and keeping in view the submissions made by the counsels for the respondents, we find that sufficient cause for the delay has been made out. Accordingly, the delay of 129 days is condoned. I is accordingly disposed of. Registry to register the appeal and list the same.
Copy may be given, my lord.
Huh?
Copy may be given. Memo of appeal, my lord. I have not heard such copy.
You serve a copy. He will.
Yes, sir.
If he doesn't on the day
My
that
lord.
he appears, then it is-
Obliged, my lord.
It's 302 case, my lord. But here, my lord, one eyewitness, my lord, only relative, my lord, brother, my lord. And other people are also gathered here, my lord. Allegation. So, my lord, after, my lord, 236 days, my lord, I pray for bail, my lord. Because otherwise, a life imprisonment is there, my lord, and 10,000 fine, my lord. Let the case be proceeded, my lord, he may be allowed to go on bail for his defense, my lord, putting any condition, my lord. But here, my lord, in the facts and circumstances of the case, it is seen that, my, in the facts and circumstances, what has been tried.
There were eyewitness.
One eyewitness brother is there, but he has told, my lord, regarding that incident, my lord, that he has seen that, my lord, the accused petitioner, my lord, has cut the backside of the, my lord, neck, my lord. But
Cut the backside of the neck.
yes, my lord. Other people, so
Okay.
broad daylight, my lord, there are 200, 300 people who are there, my lord, in the Holy Mandir near one, my lord, puja was going on, my lord.
No, but if there is an eyewitness, then what to do?
Not, but it is not,
Huh?
other has not, my lord, other, my lord,
You
witness
see,
is not corroborated.
all crimes are usually done away from prying eyes. No one does things in the open. It's usually done chupke chupke. Okay.
Mhm.
So unfortunately, one eyewitness was there. Then what to do?
Now, he is brother, my relative,
escaped, huh?
brother, he is brother, my lord. So, my lord,
Whose brother?
brother of the, my lord,
Deceased.
deceased, my lord.
Then
He has, my lord, submitted in this way, my lord, before, my lord, the court below. But other co, my lord, accused, my lord, witnesses not-
and the weapon was recovered.
no, my lord, no
Yeah,
recovery.
it's recovered, no any.
No blood samples are also not, my lord, sent, my lord, for forensic laboratory, my lord.
Let us see the main case. Yes, madam, what is your case?
In fact, PW8, he had seen them altercating initially.
Yeah.
And then he saw him giving a sharp blow on his neck. Then he ran and informed the father, I think. And then he came, and the other villagers who, after hearing hue and cry, rushed to the place of occurrence and reached there. They found the applicant shouting that I have cut him.
Okay.
The applicant was shouting, I have cut the victim.
Oh, the evidence is there to that
Yes,
effect.
that evidence is there. This is, the applicant was shouting that he had cut the deceased. And this is in the evidence of PW2, the village headman. PW2 said, PW2 did not hear, but when he reached the place of occurrence, the
Yes.
villagers told him that the applicant was shouting that he had cut the victim.
Hard.
Heard. And other villagers have also told other persons.
Her means, what do you mean?
He heard from the other villagers
person.
that
And other people were also there, my lord, but they were not exempt. Possibly 200, 300 people were there, my lord.
So 200, 200, 300 people saying that you had killed.
yes,
No,
they
my
have
lord.
said.
We
They,
disbelieve.
they were not examined, my lord.
And there is one more evidence in the shape of PW6's deposition, who said that his father was a Wakot and he had seen the incident, but then he died. That will be a res gesta
Hearsay.
evidence under section 6 of the
Therefore, it
of
was
the-
a hearsay evidence that is mentioned.
This will be res gesta evidence, evidence act advisable.
So?
And the doctors have report also corroborates there are injuries on the head and the
But
neck.
what happened to the weapon?
Weapon was not seized.
Mm.
That was, he must have taken the weapon and
Mm.
fled away. He fled.
But he was shouting, you said. He was not
He's
caught.
shouting.
I thought he was not, he ran away.
He ran.
While running away, he was shouting, I
He
killed
was
him. I killed
shouting.
him.
I don't know. He was supposed to get some money. He gives
Doctor-
some money.
Alterations will be there, my lord, for the party.
What was the problem that you had with him?
600 rupees, my lord. Demand of 600 rupees.
He owed the
Mm.
deceased.
That is
And
as it is.
this
as it
is only-
Who owed the disease?
the-
You owed, he
No,
owed.
deceased owed the money from
Yes,
the
yes, yes.
accused. He asked him. Of course, that is there only in the FIR. It is not in the substantive evidence.
22 pages.
22.
200, my lord, already, my lord, 236 days. So, my lord, as a life imprisonment, he will face, my lord.
So he was
After it is
convicted
convicted.
June 2022.
Yes, June.
So
22.
after June, he is inside.
More than 6 months. So, my lord, if it is Supreme Court says, my lord, if it is a heinous offense, if it is a heinous offense, and he has to, my lord, undergo life imprisonment, then after 6 months it can be considered, my lord. Otherwise, he will go. Definitely, he will go, my lord.
There is an
After examination.
eyewitness and all that.
Heard Mr. H. Das, Senate Counsel for the appellant who submits that. No, who heard Mr. Learned Counsel for the appellant, also heard Ms. S. Jahan, additional PP. This is an application under section 389 CRPC for suspending the sentence imposed upon the appellant to undergo RI for life and to pay a fine of rupees 10,000 in default SI for 2 months. The petitioner, the appellant's counsel submit that the appellant was convicted under section 302 IPC. He submits that the only witness to the alleged incident was the brother of the deceased, and no weapon was recovered. He submits that the allegation made against the appellant is false. Ms. S. Jahan, the learned additional PP, on the other hand, submits that the eyewitness
PW8.
bracket PW8 had clearly stated the fact that the appellant had stabbed? No,
Neck, neck, he
had
was
cut the neck.
backside of the neck.
Had cut the backside of the neck of the deceased. She also submits that PW number 2, that is the headman of the village, had heard other villagers saying that the deceased, no, that the appellant was shouting that he had killed the deceased. Next paragraph. On considering the fact that there is an eyewitness to the case and that there's an eyewitness to the case, this court, we are not inclined to allow the present application for suspending the suspension. The I is accordingly rejected and disposed of. Then in the main case, you're right. Heard Mr. H. Das, learned counsel for the appellant. And Ms. S. Jahan, learned counsel for the learned
LCR is-
additional people. Registry to call for the LCR. You did not call for the LCR.
Acha, LCR is not received, but
Hmm.
normally on the very first day
Very
itself,
first day it was stolen, my lord.
it is called, but.
16/11/22.
Huh?
16/11/22 first.
It has not been called. Where is it been called?
Acha. Simply
Not called.
notices. Sir. Acha.
Registry to call for the LCR. This is the matter after receipt of the LCR.
Double S.
This I has come up for consideration of his bail prayer and suspension of sentence.
What is the matter regarding?
Here, Lordship, the wife of the appellant was found dead in the house, and
Wife of appellant.
yes, Lordship. And the conviction is based on circumstantial evidence. Mainly, one of the circumstances is that there is no.
When did she die? When was she
The
found dead?
affair was on 27/3/2015.
Huh?
27/3/2015 affair was lost, and
26/3, 2015.
26/3 she was found dead.
Found dead on 26.
Yes, sir.
Yes.
27 she was FIR.
Yes.
And marriage was
And you
solemnized
have been
to-
in jail since then.
since then.
Lordship, since the paper book is ready, your lordship, may I pray, matter will fix for hearing?
Here, Lordship, can kindly see the last order of this honorable court, 4/1/23. There it says, I will be considered after preparation of paper book. In IA it is there. My case is that the entire case is based on circumstantial evidence. The main circumstance, the main and only circumstance, if I'm not wrong, Lordship, is that there is no explanation on the part of the appellant. This is the main ground taken by the learned trial court. And as your lordships are aware that Honorable Appellate Court had a number of times said that that burden will come only once they prove the foundation of the case. Then only the burden will shift to the accused for explanation. Only sole that ground cannot be convicted, accused cannot be convicted. Except that non-explanation, there is nothing on record. And even
When were you married?
2 years
2
back
years
from the
prior
date
to
of occurrence.
2013.
Yes, Lord.
No children.
One children is there and she is still in custody of with the appellant side. Now he is in jail, so his parents are taking care of the girl.
So his parents
that
are
time-
looking after.
At that time-
Not in the jail. What will you do with the jail? Men cannot look after small,
Yes.
small children. You're married?
Yeah.
No, you as a lawyer.
Oh, yes, Lord.
You're married.
Yes.
Do you look after your baby when 1 year, 2 years, clean up everything, do everything? No, I don't think so.
That
Wife will be doing everything.
Yes.
Anyway,
here only that is the ground, Lordship. If your Lordship finds the evidence, there is no record or there is nothing on record to show that at the time of occurrence he was at the house. Even if your Lordship we assume that he was at the house, then also Rina Hazarika's case, Honorable Apex Court has said that they have to show that there is some ingredients of the offense. Then only burden will shift.
was there any complaints being any?
Never,
any
never,
Yes,
never.
yes.
Huh?
There was village picture earlier. Relationship was not good amongst them,
Okay.
between husband and wife.
But no FIR, nothing has been lost. It is in the evidence of the PW1 itself.
How did she die?
As per postmortem report, manual strangulation.
Strangulation.
But even if that Lordship, in that case, Lordship, this case is based on circumstantial evidence. The circumstance which is not put to the appellant cannot be used against it. So that manual strangulation, that is not put to the accused in his 313. Lordship, may I kindly see
It is 313.
313. That page 26, your Lordship will find is 313. 26.
26 of the paper book.
Oh, Lordship. Sorry, Lord, page 29. Sorry, page 29. Page 26 is the father of the appellant who is acquitted in the present case. No question regarding doctor's evidence.
You have not answered with regard to whether there was a bichar held in the village.
It is not denied by him, and he said
Where?
page question number 2, Lordship will find.
Question number 1.
Yes.
Question number 1.
Yes, Lord.
You had been torturing your wife Asma by assaulting and abusing her, that a bichar, bracket extrajudicial trial, was held in the village
Yes.
and over the matter, and that the dispute was settled in bichar. What do you say? You have kept silent here.
He said, Lordship, I never misbehaved with her or assaulted her.
No, that is a different issue.
Lord.
Was there a bichar held?
Lord.
And whether your dispute was settled in the bichar. Why have you kept quiet with this issue?
In question number 4, he said we led question number 3, Lordship. He said we led happy married life, Lord.
I'm not on that. No, again.
Just I am placing one judgment of Honorable Appeals for Lordship, three judges bench, because Lordship, the trial court mainly relied on Trimukh Maruti Kirkan case, and this judgment has discussed that judgment of Trimukh Maruti case. Therefore, I am relying on.
Why can't we decide the entire issue at one
Yes,
go?
Your Lordship, that I was submitting.
Because it will
Since the
take
paper
time
book
in
is
the-
ready, Your Lordship.
If your Lordship fix a date, then I have nothing to say. By keeping the IA pending, because sometimes it takes some more time, Lordship, then I can face for IA in that case. But as I have placed, Lordship, what I found, Lordship, there is no material to connect the appellant with the crime, Lordship.
No, but yes, there is no doubt 313 cannot be used for conviction. But when you don't answer a question, okay, the court can very well draw an inference
Right.
with regard to the non-answered question.
But even if we admit that part, Lordship, that prior to her death, she was assaulted and Bichar was held. But they have to prove it, they have to link that with the crime, Lordship.
Correct.
That evidence is not there. That due to torture, she was killed. That evidence is not there. Both are different place, Lordship.
No, she died inside the. Oh.
Lordship, for a moment, the judgment which I have placed of Honorable Appeals Court, for a moment, Lordship. Page 80, paragraph 18 and 19. Paragraph 18 and 19.
18 and 19.
May I read, Lordship?
Yes.
Section 106 of the Evidence Act postulates that the burden of proving things which are within the special knowledge of an individual is on that individual. Although the section is no way exonerates the prosecution from discharging its burden of proof beyond reasonable doubt, it merely prescribes that when an individual has done an act with an intention other than which the circumstances indicate, the onus of proving that specific intention falls onto the individual and not on the prosecution. if the accused had a different intention than the facts are especially within his knowledge, which he must prove. Now 19 paragraph. Thus, although section 106 is in no way aimed at relieving the prosecution from its burden to establish the guilt of an accused, it applies to cases where chain of events has been successfully established by the prosecution, from which a reasonable inference is made out against the accused. Moreover, in a case based on circumstantial evidence, whenever an incriminating question is posed to an accused and he or she is either evades response or offers an response which is not true, then such a response is itself become an additional link in the chain of events.
Madam,
this is
Mr. Counsel, when was it found out that she had died? What time?
Lordship,
Morning 5 a.m.
5 a.m.
5 a.m. in the morning.
Yes.
He was not present in the house. That is my.
Where was he? Where was he?
He was at Guwahati, Lord.
They have prosecuted a
The
case that 15 days
DWs were-
prior to that he was in Guwahati. So Lordship, LCR will reveal, your Lordship, with the deposition of the witnesses. So Lordship, date be given
No,
for
5
hearing?
a.m. it was
No,
found.
just
Yes.
Found by whom?
found by the family members of
Family
the
members.
accused.
Family members.
Yes. Immediately neighbors
And
also.
you were
neighbors-
in Guwahati.
Yes, neighbors also.
You have an
immediately-
alibi.
Yes, Lord. I was in Guwahati.
He did not take that plea in
Yes, clear
312.
failure.
Have you
Alibi
taken
DW2 is there. No, initial.
But she was strangled.
manual strangulation?
Manuel.
Strangled.
That's what I have understood from this judgment, which what is said, that first they have to prove the chain of event. Here in this case, Lordship may kindly ask the.
And
public
I
whether
think we'll, I think we
any-
will hear the appeal.
Yes,
Ah,
yes.
the appeal, the IATO will dismiss.
Lordship may keep it pending, Lordship. Otherwise, it may take time or again I have to come and this the same bench will have to constitute. Then it will create a problem, Lordship. If it is kept pending, then. I can-
Why? It's the same thing for all other cases. Same thing.
Lordship may observe it that matter.
You
is-
see, your wife is found dead at 5 a.m. in the morning.
Lordship. But in that case, Lordship, that prosecution may have to show that I was in the house. There is nothing on material on record. Even I have produced the DW. DW also said that they have come to know that I was not in the house.
What work are you doing?
I am labor, Lord.
Labor.
Lord.
So no one will really miss you whether here or there.
Lord. But my only case is that, Lordship, there is not a single evidence to show that I was in the house, because only then the 106 burden will come under me.
Right. In the main petition, you write, on the prayer of the parties, this is the matter for hearing. In usual course, it come in as much as paper book has been furnished to the parties.
Yes.
And in the IA to be discussed,
I have kept pending, Lordship,
we want, it is here. It is here for disposal, will dispose it.
because on merit, Lordship, I have submitted and
Merit, you try your luck with merit.
Lordship, in this matter, we are filing our objection. It's under process, my lord, during the course
Ms.
of the
B.
day.
Boyan, additional PP is granted.
Lordship, it will be
Is-
today only.
Is
1 week time?
Is
It
granted
may
a
come up
week's
in-
time, is granted a week's time to file written
Yes.
objection. This is the matter after the week. Miss Miss Roshana Sultan. Miss Begum Roshana Sultan.
Sultana.
Sultana appears for point number 2. Paper book has been given.
The paper book is not ready.
Show me the main case. No, you are the main case. You both. That becomes the problem. Has the LCR been called for?
LCR is received, my lord, as
LCR
part of
is
cause
received.
list.
Okay,
yes.
right. Miss S. Sharma appears for the appellant,
Yes, your
while Ms. B. Boyan, additional PP, appears for point number 1. Ms. Begum Roshana Sultana
Yes.
appears for point number 2. As LCR has been received, registered to prepare the paper book. List the matter after.
Lordship, if the IA comes
Ah,
and,
that's-
if both
that's-
are kept together, Your Lordship,
Just that,
then in
just that.
one-
Prepare the paperwork.
yes.
This is a state appeal, Your Lordship, against acquittal.
No.
This item.
Okay.
Here, the accused was acquitted under section both 376 and POCSO.
And for acquittal, do you have to file any application?
Yes, this is a leave application that is
Oh.
before Your Lordship.
Okay, this is a leave application. So you have to issue notice.
Lordship.
Heard Miss S. Jalan. Additional PP. Jalan or Jahan?
Jahan.
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 Jahan, additional PP. Who submits that the judgment and order dated 1/9/22 passed by the learned sessions judge cum special judge, Morigaon.
Mm.
In POCSO case number. No, acquitting the respondent of the charges under section 450
yes.
slash 376 bracket 2 bracket
One,
I
yes. I,
of the
yes.
Indian Penal Code read with section 6 of the POCSO Act 2012. In POCSO case number 6 of 2019 should be set aside. And leave should be, leave should be granted to the state. To file the appeal. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondent by registered post with AD within 3 days.
Lordship,
3 days.
Lordship,
List the matter after 4 weeks.
Lordship, obliged.
May I please, Your Lordship? This is a delay condemnation application.
Huh?
This is a delay condemnation application.
Application, okay.
There are 69 days delay. in filing
This
the
is for
appeal.
what? This is an, who is filing the, you are filing?
I am also the legal aid counsel.
This is item 15. Okay. How many days?
69 days.
It may be
Any
condoned,
objection?
it may be
Okay.
condoned.
Right, third, Mr.
Yes.
J. Das, learned counsel, legal aid counsel for the applicant who submits that the delay of 69 days in filing the appeal against the judgment and order of conviction and sentence dated 30/07/22 passed by the learned additional session judge dash special judge POCSO in case number special bracket POCSO bracket close 6/2019. Wherein the applicant has been convicted under section 6, convicted and sentenced under section 6 of the POCSO Act 2012. Should be set aside. Should be allowed. Should be allowed. Ms. B. Boyan, additional PP. Who else for the, what about the respondent? Two?
Lordship, nobody's name is shown. Notice should go, my lord. For the first time it has come. Appeal be registered. Who is the registered?
Registered but not admitted.
Okay. Lordship, let the appeal come up for admission.
No, no. What about this 69 days? Is who is the peri for us? Is a POCSO case?
POCSO nahi ke.
POCSO case.
POCSO.
So notice will have to go.
Notice should go.
Then we should- Side headache. Issue notice to the respondent number 2. Applicant to take steps for service of notice upon the respondent number 2 by registered post with AD. Oh, no. Registered. Take steps for service of notice upon the respondent number 2 by registered post with AD within
Within 2 days, 5 or?
within no, don't say within. List the matter after 4 weeks.
Obliged.
Item number 5, I was amicus curiae, my lord. My name shown as full name, my lord. That is why nowadays printed list is not coming. So we have to search in the my lord website by short in abbreviated form, my lord. So that is why I skip item number 5, my lord. I was there, my lord.
So you want your name to be reflected?
Yes, my lord. NK Polita, that is my lord.
What have we done in this case? Item
Lordship
5.
is fixed for hearing.
I have not collected the paper book, my lord. That is all.
Oh, then you
I'll collect it, my lord.
correct it. You go and collect it. So your name, you want your name to be there?
My lord.
Okay, in item 5, just tell them, Mr. N.K. Kalita, amicus curiae appears and submits that he has not received a copy of the paper. Just say that.
Obliged.
Lordship, this has came for the first time. There's a delay of 98 days. So notice may go, Lordship.
Is it a POXO case?
No, Lordship, it's under 370 subsection 5 of the IPC. Human trafficking, Lordship.
Human trafficking.
14 years, Lordship.
Yes, 98 days. What?
Lordship may
Heard
condone.
Mr. B. Chakraborty, Learned Counsel for the applicant who submits that there is a delay of 98 days in filing the appeal against the judgment and order dated 12/8/22 passed by the court of
No, Lordship, by the session judge.
passed by the
Sonitpur.
session judge Sonitpur in sessions case number
88 of
88/2018, by which the applicant has been convicted under section 370 bracket 5 IPC and to undergo RI for 14 years and pay a fine of rupees 5,000, in default SI for 3 months. Ms. B. Boyan, additional PP, submits that she has got no objection. Who's number 2?
It's the informant, Lordship.
Submits that she has got no objection if the application is allowed. Next, on considering the grounds for condoning the delay and keeping in view the submission made by the additional PP, we find that sufficient cause for the delay has been made out. The delay of 98 days condoned, I is accordingly disposed of. And the registry to register the appeal and list the same accordingly. Also hearing this. What to do if they're not here? And this hearing, this is for how long? So we don't need passing an order.
First
Anybody-
one is the writ appeal, your lordship, then thereafter criminal appeals.
But there's no one present, what to do?
Yes.
And this is a
Lordship.
FT case.
Yes,
FT.
probably wrongly it has come. I don't
How
know.
come FT should not be here? FT should go to Justice Bujal Barwa.
Hmm.
Anyway, it's okay. No one is here. Anybody ready for hearing? No, someone has to step up.
Lordship may notify in the notice, like in a notice column, that this court will take up part to hearing list. It's given in the cause list.
Ah.
But then
Apart
again-
from that, yes,
Again,
yes.
giving in the display, because otherwise these councils, they do cases. They must have skipped, or they might not have noticed. So one thing in the display.
Huh.
Bengali, Bihar, Devastate,
At 2 p.m.
Mojumdar, Kongoya,
And what we do in between? At 2 p.m. we can do.
Lordship, may I pray?
But I don't know, madam. Today, so no point. Because they won't be ready. How will they suddenly? They will not be.
In a notice column, your lordship.
No, what else?
No, not in the
Today, of course, they might
Today
not.
no,
yes, in a
there's no-
notice, my lord,
Ah.
that this court will take up part two hearing list immediately after completion of the part one.
Only problem is sometimes we get the single bench matters.
Yes,
also,
my-
actually. That is the, we do not know. We can do that. That's not a problem. You're right. From tomorrow. Have we got any? Tomorrow is it possible? Okay, do that. What is for you? Also, no need of, no need. From next week, maybe, if we are still, the bench is still. This is long time I'm sitting in a criminal
Yes.
bench.
Your lordship used to sit maybe 2 years
No,
earlier.
not 2 years. In 2015.
No,
Only in 2015 with
also twice your lordship used to sit.
the criminal matters I never sat. I sat only with Justice P.K. Saikia.
Saikia, that was about, I was about to
Ah,
say.
you were there. I had to sit this side
Yes.
and Justice Saikia used to feel very cold at times with the AC. I liked it cold. He liked it slightly, warmer temperature.
Justice Saikia is not well at all. I
Acha.
mean, he had some pancreatitis operation done at
Okay,
Hyderabad,
okay,
a very
okay.
major operation.
Okay.
Some part of his pancreatitis is cut.
Oh, okay.
He is in total bed rest now. He's back to Guwahati.
I remember Justice P.K. Saikia and I sat together and this senior lawyer from Delhi, he came and he was arguing before us. And then 1 or 2 years later, he became a Supreme Court judge. Justice Nageshwar Rao.
Nageshwar.
He used to come here very often.
Ah. Anyway, okay.
Okay.